Hello and welcome to the Minimum Competence episode for Wednesday, September 17th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, KPMG's audit failures, a Tesla crash settlement, terrorism charges dropped in a high-profile murder, and law firms suing Trump despite prior deals. Let's remember, life starts all over again when it gets crisp in the fall, and read today's legal news. On this day in legal history, September 17, 1778, the Treaty of Fort Pitt, also known as the Treaty of Fort Pitt or the Delaware Treaty, was signed between the newly independent United States and the Lenape, Delaware nation. It was the first formal treaty between the United States and a Native American tribe, signaling an alliance during the Revolutionary War against British forces. The treaty, negotiated at Fort Pitt, which is present-day Pittsburgh, Pennsylvania, promised military collaboration, mutual defense, and provisions for supplies and protection for the Lenape people. In a striking and largely symbolic provision, the treaty even entertained the idea of creating a 14th state within the Union to be governed by Native Americans. Though the treaty framed the Lenape as equal partners, its promises were quickly eroded by reality. The United States failed to deliver many of the resources it pledged, and the idea of a native-governed state was abandoned almost as soon as it was proposed. Lenape leaders had agreed to the treaty in part out of necessity, caught between colonial and British expansion, and hoping to safeguard their people's survival. Instead, they faced encroachment, displacement, and repeated betrayals. Within a few years, American militias and settlers would violate the treaty's terms, seizing land and disregarding Lenape sovereignty. The alliance never materialized in the way it was envisioned. The treaty, once a beacon of potential cooperation, became an early example of the fragility of Native American treaties with the United States. It set a precedent for broken agreements that would recur throughout American expansion. A Senate report released by Democrats on September 17th criticized KPMG LLP for failing to act on warning signs at Silicon Valley Bank, Signature Bank, and First Republic Bank prior to their 2023 collapses. The auditors issued clean reports just weeks before the banks failed due to rising interest rates and liquidity issues, yet they allegedly ignored key red flags, such as massive asset devaluations, governance concerns, and internal risk assessments. Lawmakers said KPMG adopted an overly narrow view of its responsibilities and maintained close, long-term relationships with the banks, raising questions about its objectivity. The report highlighted a revolving door between KPMG and the banks, with executives and audit staff frequently moving between roles. KPMG defended its audit, saying it followed U.S. standards, and criticized the report as out of step with other investigations, which have not blamed auditors for the failures. Senator Richard Blumenthal called for substantial reform to the audit industry, citing willful blindness by KPMG and a failure to protect the public. Though the Senate subcommittee's report is unlikely to spur immediate regulatory changes, especially given the political instability at the PCAOB, it proposed new oversight rules, including mandatory auditor rotation and a whistleblower office. The report also recommended making audit enforcement investigations public sooner, arguing that longer delays leave investors unaware of potential problems. KPMG, meanwhile, noted it had improved its audit practices and achieved its best regulatory inspection in 15 years. A New York State judge dismissed 2 terrorism-related charges against Luigi Mangione, who remains accused of second-degree murder in the killing of health insurance executive Brian Thompson. Justice Gregory Caro ruled that prosecutors failed to provide sufficient evidence that Mangione acted with the intent to intimidate health workers or influence government policy, criteria necessary for charges under the state's terrorism statute. While the judge acknowledged the seriousness of the crime, he clarified that not all non-traditional crimes qualify as terrorism. Mangione, 27, still faces 9 other charges in the state case, including multiple counts of criminal possession of a weapon and a charge for possessing false identification. He has also been indicted federally, where the U.S. Department of Justice is seeking the death penalty. The state court's decision does not impact the federal terrorism case, which remains active. Thompson, a former CEO at United Healthcare, was shot outside a Midtown Manhattan hotel in December of 2024 during a company event. The case has drawn national attention, particularly as concerns grow over politically motivated violence following the recent killing of conservative activist Charlie Kirk. Public reaction to Mangione has been sharply divided, with some viewing him as a vigilante figure amid frustration with rising healthcare costs. Supporters even rallied outside the courthouse holding signs and wearing themed attire. Mangione has pleaded not guilty to all charges, and no trial dates have yet been scheduled. Several major U.S. law firms that reached agreements with President Donald Trump earlier this year are now representing clients in lawsuits against his administration, despite concerns that the deals would deter such actions. At least 4 of the 9 firms that made arrangements with the White House, Latham & Watkins, Wilkie Farr & Gallagher, Skadden Arps, and Milbank, have since taken on cases involving challenges to Trump policies on immigration, transgender rights, tariffs, and environmental regulations. The firm's deals with the Trump administration, reached in March and April, came in response to executive orders targeting firms seen as opposing the president's agenda or promoting diversity policies he opposed. As part of the agreements, the firms pledged nearly $1 billion in pro bono legal work for causes aligned with the administration. Critics feared the arrangements would chill dissent and limit the firm's independence, but court records show several firms continue to litigate against the government, at least in part. Legal experts suggest these firms are balancing risk with professional obligations, especially in high-profile cases involving long-standing clients or influential attorneys. For example, Latham represents Danish energy company Ørsted in a lawsuit over a halted wind project, and Wilkie is defending Virginia school districts in a transgender rights dispute. Milbank is involved in litigation over Trump's tariff powers and sanctuary city policies, led by prominent attorneys Neil Katyal and Gerber Gruhl. Skadden has partnered with a nonprofit to represent an immigrant woman denied a special visa. 4 firms successfully challenged the legality of Trump's executive orders in court, with rulings finding they violated First Amendment protections. The administration has appealed. Meanwhile, Reuters reports that other top firms have reduced pro bono and diversity initiatives, cautious of possible political retaliation. Tesla has reached a confidential settlement with the family of Giovanni Maldonado, a teenager killed in a 2019 crash involving a Tesla Model 3 operating on autopilot. The case, which was set to go to trial next month in Alameda County, adds to a string of fatal crash lawsuits the company has quietly resolved to avoid jury trials. The Maldonados allege that Tesla's driver assistance system failed to detect slowing traffic and that the car struck their Ford Explorer at 70 miles an hour, ejecting and killing 15-year-old Giovanni. According to the lawsuit, the Tesla driver had no hands on the wheel at the time of impact, and the family claimed Tesla misled the public about the safety and capabilities of its autopilot technology. Although Tesla argued the technology worked as designed and blamed the driver, it continues to settle similar cases even after Elon Musk publicly stated in 2019 that he opposed settling unjust lawsuits. The company has also recently settled other high-profile fatal crash suits, including ones involving distracted drivers and cases with alcohol-related elements. These legal battles come as Tesla faces mounting scrutiny over autopilot and its marketing practices. The California DMV is pursuing an administrative complaint accusing Tesla of exaggerating its software's capabilities, with a ruling still pending. Tesla has 3 more fatal autopilot crash trials scheduled in the next 6 months, including one in Houston involving injured police officers. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow. And until then, remember, autumn carries more gold in its pocket than all the other seasons combined.